Senior executive clients often claim that their restrictive covenants aren't worth the paper they're written on. Employer clients, on the other hand, tell us that they think their covenants are watertight, even though they use the same contract every time they hire someone, and they've been doing that for the last 10 years. Of course, in reality, it's not that simple. All employment contracts contain an implied term that the employee will serve their employer with good faith and fidelity. The standard that applies in terms of the duty of fidelity varies on a case-by-case basis. The more senior the employee, the higher the duty of fidelity that applies. But in any event, the duty of fidelity prohibits competition with the employer during employment. Depending on the circumstances and the individual's seniority, the duty of fidelity during employment can even prohibit mere preparation for future competition with the employer, like setting up a new company. The most senior employees, like company directors, partners or desk heads, also owe what are known as fiduciary duties. That means they have a duty to act with undivided loyalty, solely in the employer's best interests. And it also means that generally they have to resign before they can take any steps in preparation for future competition with the employer. Once the employee has left their employment, there will no longer be any duty not to compete unless there are restrictive covenants. Restrictive covenants will prohibit things like working for a competitor business, dealing with clients, soliciting clients, poaching colleagues for a defined period after the termination of employment. The reality of restrictive covenants in employment contracts is they're only enforceable if they go no further than reasonably necessary to protect the employer's legitimate business interests. What do we mean by legitimate business interests? Well, it's things like their confidential information, the stability of their workforce, their client connections, their trade connections, that sort of thing. So the test for enforceability is a strict one, but equally the litigation environment in the High Court in recent years has generally been quite favourable for employers seeking to enforce their restrictive covenants and tough for employees wanting to go into competition with their employer. We've seen lots of injunctions granted against senior executives prohibiting unfair competition with their employer. But the fact remains that if a restrictive covenant is too broad in scope and too widely drafted, the court must find that it's unenforceable. To give you an example from a recent case, there was a claim against the global head of financial services at a headhunting firm to enforce her 6-month non-compete clause, and it was found that the covenant was too wide in scope to be enforceable. That was because it prohibited the holding of any shareholders in competitors, even very minor ones, and even simply as passive investors. It didn't matter that she didn't have a shareholding in a competitor, and she didn't even want to get a shareholding in a competitor. What she wanted to do was to join a rival before her 6-month non-compete period was up. This case should therefore serve as a real warning to employers to take care over the drafting of their restrictive covenants, and also to review the existing clauses, particularly in the case of their key senior employees, and to consider putting in place new covenants when people are promoted into key or senior positions.